Hello and good morning, good evening. This is Law and Society, and thank you for being here. When lawyers on the appellate level write briefs and get ready for their appeals, they often argue and bring in points from both sides of the argument, all sides of the argument, in order for them to strengthen their own case. So, in the last three episodes, I have explained the Colorado Supreme Court's long decision as about why it finds that Donald Trump is disqualified from the election ballot in Colorado. Now, this episode, I will play the devil's advocate and I will bring up the points that the dissents brought in the case, as well as some other defenses, some other arguments that Donald Trump could use uh, in order to, uh, have Colorado Supreme Court's judgment thrown out. So it's important for us to see what the weak points of this case are and be aware that it is possible for the Supreme Court to overrule the Colorado Supreme Court's order disqualifying Donald Trump from being on Colorado's presidential ballot. So the first place that I looked for that were the dissents of the majority opinion. And the dissent, there were three dissents, and they each wrote their own reason for it. And two of them had to do with jurisdictional as well as interpretation of the election code. And one of them had to do with the lack of due process of law under a circuit precedent called Griffin. So let's talk about these things, right? So due process of law. So we have due process of law under the Fifth Amendment and the 14th Amendment. And in this case, uh, what happened was there has been no conviction of insurrection. So no criminal action has taken place. So the beyond a reasonable doubt due process of law standard has not been applied to this test. However, as the Colorado court makes clear, that it had used the standard of clear and convincing evidence, which is a higher standard than preponderance of the evidence and a lower standard than beyond a reasonable doubt. So the due process that happened in this case, one side can say, no, they didn't get due process of law because there was no conviction, there was no arrest, there was no fact finding in the sense of the criminal act. But this is a constitutional exercise, and whether Section 3 of the 14th Amendment uh, requires application based on clear and convincing evidence or beyond a reasonable doubt, that the amendment doesn't say. But it is definitely a heightened burden of proof that the court employed in this case, and that would be the argument there. But there is an argument that due process of law wasn't had in this case. So, as I've said before, my professor always told us that the Supreme Court can do whatever the heck it wants. And he didn't say heck, he used another word. So the court could disagree with how Colorado Supreme Court interpreted its authority. It could say that it ruled, it can also say that the election law that they were talking about is unconstitutional, but I doubt that they would go in that direction. So they can use the fact that the lack of standing, they can talk about the lack of standing, but there's the Colorado Supreme Court's opinion and the state statute that gives them standing. So that argument is also kind of weak. Uh, the court could then overrule Colorado's case by the standing and other political question grounds. And this is the reason why I believe that besides deciding the substantive case of whether Donald Trump engaged in insurrection and whether office of the president is one of the offices included in Section 3 of the 14th Amendment, that's the substance of the issue. What the Colorado Supreme Court did was it also went beyond and talked about standing, talked about how the election code that at issue here gives Colorado voters the standing required to bring this suit, and also goes into the specifically the political question grounds, and goes through and says that it hasn't been committed to another department, political department, and therefore it is the court's job to answer, even if it's difficult judicial questions. So then the other argument is that the enforcement clause of the 14th Amendment, which is Section 5 of the 14th Amendment, gives Congress the power to legislate the provisions of the 14th Amendment. So Congress didn't legislate and said that, and so SCOTUS can say that Colorado was wrong because Section 3 was designated to another political department, namely Congress. So it depends. Now the case comes at a very interesting time, because the justices who sit in the Supreme Court of the United States are heavily tilted conservative, and conservative federalist right-wing judges focus a lot on states' rights. As I pointed out, as the Colorado opinion points out, then Judge Gorsuch actually wrote in one of his opinions when he was a judge that states have the power to regulate the qualifications. So which direction will Gorsuch take? Which direction will the other judges take? Is difficult, because there are so many other ancillary things that the Supreme Court can do to say, okay, no, due process was not had, so we can't. This was incorrectly ruled. The election code is overbroad, and it wasn't designed to take presidential qualifications into consideration. Then they can talk about the enforcement clause of the 14th Amendment, Section 5, and all of these grounds, and then bring up political question grounds and standing, and because it was talking about holding office, Donald's attorneys can even say that it's not about being on the ballot, it's about holding that office. So the case isn't even ripe yet until the time comes that Donald is in a position to hold the office. So there are all these arguments that counter the Colorado Supreme Court's opinion. But in 134 pages, the Colorado Supreme Court, the majority, did a fantastic job of addressing as many of these as they could. They didn't, from my recollection, deal with the enforcement clause. And that may be one of the stronger arguments that Donald would have is, Congress didn't legislate. And, the Constitution did designate Congress under Section 5 of the 14th Amendment to enact the provisions in the 14th Amendment. So that is an argument counter to the argument that each section of the 14th Amendment is self-executing, which, Section 1, the Equal Protection Clause, Due Process Clause, those are self-executing. And so that I wanted to come and I wanted to give y'all an idea of what the arguments, the opposing arguments are going to be. I'm not saying that they're strong arguments, but what I'm saying is that the dissents have written about it, and Donald Trump will be using some, if not all, of these reasons when it asks for the Supreme Court to throw out the Colorado ruling. So, with that said, I don't see any questions. Hey, Deb, thank you for being here. I will come back again when there is something new to talk about. Take care.